meeting. This meeting is being recorded.
Good evening, everybody, and welcome to our City Council special meeting today, February 24th, 2020. We're going to call the meeting to order at 6 p.m. today. Monica, can you please call, could everybody stand and pledge of allegiance? Ready, begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And can you guys please remain standing for a moment of silence for our first responders and military members? Thank you. Thank you. Monica, could we get a roll call, please?
Roll call. Councilmember Soto?
Present.
Councilmember King?
Present.
Mayor Pro Tem Garcia?
Present.
Mayor Aguilar?
Present.
For the record, Councilmember Moran is currently not in attendance, but his attendance is expected soon.
Thank you, Monica. In
I'm
addition,
present, Monica.
what was that again?
Councilmember Moran?
Present here on the
Okay.
phone.
Thank you. And in addition to that, could you please have everybody on the phone or on Zoom identify themselves for the record? I know we have a number with the last four, 9106. We do have a number with 7018.
Jason Roth.
Thank you, Jason. How about a number with 3417? And I think everybody else's names on the screen, I believe. We're going to move on now to our citizen comments. At a special meeting, members of the public wishing to address the council for any matter on the agenda may do so at a time the matter is discussed. No, under the provision of California Government Code, the City Council is prohibited from discussing or taking action on any item not on the agenda. Comments are normally limited to 3 minutes. Do we have any citizen comments? Hear none. So we're going to move on to our workshop for AB 1234 Ethics Part 2 and City Council, City Manager form of government training. Our facilitator tonight, as yesterday, was Trevor, our City Attorney. Go ahead, Trevor.
Thanks, Mayor. Good evening, everyone. Welcome back. I'll try to make this hopefully as painless as possible. But this is the continuation of the AB 1234 training, and we're also at the end of this subject matter going to specifically cover the City Council, City Manager form of government, which the City of Livingston, as a general law city, has adopted as its form of government. So right now, if I could have the option to share the presentation.
Should be able to now.
I don't think it's working.
Hey, Trevor, try it again, because I saw that he gave you the host capabilities.
It says host disabled, participant screen sharing.
Hey, Trevor, can you give up the hosting capability up again, and then we try it over again?
Sure. There we go.
We got it?
All right. So can everyone see, hopefully?
Yes.
Great. So this is where we picked up or left off yesterday, where we were covering meetings and the Brown Act, and specifically 3 or 4 different types of meetings. We had regular meetings, special meetings, emergency meetings, and adjourned meetings. These are 6 exceptions to those meeting requirements, which is individual contacts. So that's if council members are going out and taking individual meetings with constituents, business owners, other members of the community, so long as there's not a quorum of the council or commission or board, those individual contacts and meetings are perfectly fine. The same exception applies for a quorum of the council, commission, or board that attends a conference. And so, a common one might be the League of California Cities annual conference. The Brown Act allows for a majority of the council members to be in attendance at those conferences, so long as you're not discussing anything within the subject matter jurisdiction of the city. That doesn't mean that you can't receive information regarding things that might be within the subject matter jurisdiction. You would just need to ensure that in your conversations with your fellow council members, commissioners, or board members that you're not discussing anything within your board, council, or commission's jurisdiction. There's nothing that prevents a quorum of the council from attending a social ceremonial event. And then even a council member can attend standing committee or an ad hoc committee meeting, just a standing committee meeting. If it's already been agendized, another council member is more than welcome to sit in and listen in the meeting. However, they can't participate in the actual decision-making process. Oh, and the one I left out here is if a quorum of the council or commission or board can attend another body or a public agency public meeting. Again, so long as that meeting has been properly agendized, and otherwise those members, the quorum is not discussing amongst themselves issues that are within the subject matter jurisdiction. Serial meetings. So these are next examples or types of instances that might lead to violations of the Brown Act. And the first one is what's known as these types of serial meetings. And there's two examples of what these serial meetings look like. And it's where a majority of a board, council, or commission deliberates outside. So an example would be a board member or a council member communicates with members of the rest of their council, board, or commission. So it could be either a board member or a single member. And the example here for hub and spoke is if you imagine staff member, board member, or council member being the hub, that one communicates to a majority of the other council members. In essence, that specific council member has created what's known as a hub and spoke serial meeting in violation of the Brown Act, because what you've done here is you've now found out or informed the quorum of the board, commission, or council how outside of a properly agendized Brown Act meeting, and to a certain extent, you might be revealing other council members' positions, viewpoints, how they feel. And those should be really reserved, those conversations regarding when you're having a quorum of a discussion should be reserved for a properly agendized Brown Act meeting. A daisy chain example is sort of like a telephone game to where Councilmember A contacts Councilmember B and Councilmember B contacts Councilmember C and so on and so on. If you're relaying a message to each person, that's carried on through each member. And if you can picture like a daisy chain of tied together, that's how it would also potentially be a Brown Act violation because, again, a quorum or majority of the board, commission, or council would have then been notified or have information that should have been discussed at a Brown Act meeting in open session. Another thing to be aware of, and is a lot of times when if I'm emailing the entire council or commission or board is I will BCC all the members. And what that does is prevent a reply all. So if there's an email that goes out to all the planning commissioners and it has some substantive information in it, if a commissioner responds by reply all to all the other commissioners, including even if there's legal counsel attached to that email, that could lead to a Brown Act violation because, again, you're communicating with a quorum or the majority of the board, commission, or council. So just something to be aware of. If there's an email and you see at least a quorum or majority of your fellow council members on the email or commissioners on the email or board members on the email, you just want to be mindful that you don't reply all. If you want to speak to one of your individual colleagues directly, that's something you should do, and maybe forwarding the email to that colleague and having that discussion that way. So just be mindful when you're doing a reply all. So this is a new law that went into effect this year, AB 992, regarding public officials' use of social media. What the law stipulates is that for public officials, your social media usage, that's Twitter, LinkedIn, Facebook, Instagram, if it's done through your official account or used to publicize city business or your role in participating within city government, that is subject to Brown Act rules. And so the Bright Line rule is that members of a legislative body may not respond directly to any communication posted on the internet by other members of the same legislative body regarding a matter within the subject matter jurisdiction of the legislative body. So this obviously would not apply to situations where if another council member has a post about a birthday party or some other like personal events, maybe a photo, a vacation, or a travel, obviously the council member is more than welcome to comment directly on that post. If it's a post publicizing a specific city action that was taken, you want to be very mindful of whether you're liking, commenting on that. And this gets a little bit trickier with Twitter if you're retweeting. Theoretically, under this law, although it hasn't been tested, it's arguably a violation of the Brown Act if it's done by another member of the legislative body. Now, if it comes directly from a city-sponsored account, because that is not the account of a council member, commissioner, or board member, and is done through the official city account, there's nothing prohibiting a council member, commissioner, or board member from liking that post or retweeting it or copying, or linking to that post directly. I'm sorry, was there a question? Okay. So these are the Brown Act rules regarding video or teleconferencing pre-COVID-19. And it's a member of council or of the board or commission is going to be participating telephonically or remotely. The agenda was required to be posted at all locations where the council member would be participating from, or council members if there were more than one participating remotely. The location from which those members were participating from are required to be open and accessible to the public. And a quorum of the board is required to participate from within the jurisdiction of that particular entity. With the new executive order suspending the Brown Act teleconference requirement, and this is Executive Order N-29-20, and it has been extended pretty much for the near future. And what it says is all of those rigid requirements for the Brown Act in regards to teleconference participation have pretty much been suspended to the extent that the public entities themselves provide a meaningful way for the public to participate either telephonically, so that would be through conference calling, or through otherwise electronically, like, for example, we're using the Zoom platform, if that's Microsoft Teams. And what they've clarified is that it's permissible to use a combination of video conference and teleconferencing or one or the other. So, for instance, if the city didn't have the ability to do Zoom, it could conduct the entire meeting telephonically, and that would include having the ability to be in person as well. And so as far as we're concerned, given the current levels of COVID-19 infections and hospitalizations and the different tiers within the county, we don't foresee that these, emergency rules that have been established by the executive order being revised or suspended anytime soon. So for the foreseeable future, the city has the ability to utilize these modified video conferencing and telephonic conferencing abilities to conduct its public meetings in compliance with the Brown Act. And again, these are just continue on some of the things I touched upon earlier, that the location of each council member, commissioner that's participating remotely doesn't have to be accessible to the public. There's no requirement that at least a quorum of the commission, council, or board is participating within the jurisdiction of the city. All those requirements have been suspended. So it's really sort of an innovative way to approach complying with the Brown Act in the stage of COVID. So it's something I think, the city has taken advantage of to a certain extent, and in many other cases it's allowed in some circumstances for greater participation since people are able to participate from their homes or locations and not having to physically be at city council chambers. And agenda and notice requirements. So agendas are required for every emergency meeting, regular, special meeting, and emergency meeting. They have to contain the time and location, for a brief general description of each item of business being transacted or discussed at the meeting, including closed session items to be discussed. It also every meeting has to include a public comment period for members of the public to comment on any item that's not on the agenda, but within the subject matter jurisdiction of the city. Generally, each item of business need not exceed 20 words. The rule of thumb I like to use is that you want to convey enough information in the agenda title to inform the public of what's going to be considered. So, action verbs are important if it's going to be a discussion and direction or consideration and approval. You want to make sure that when you're compiling the agendas, and the city, Monica does a great job with the city in putting these agendas together, that the agendas contain enough information that if someone who's interested in learning about the city, what's going to be considering, can have a general idea of what that item is going to be about, and then make an informed decision as to whether they want to participate. These are the agenda and notice requirements that we had covered earlier, 72 hours for regular meetings, 24 hours for special meetings, emergency meetings. Again, there's no specific time requirement. However, we like to recommend that you give at least an hour notice and then inform the media entities and other entities that have been requested to be informed of agenda, to receive agendas. So here are some of the general meeting rules covered by the Brown Act. No one is required to sign in order to attend. If the city chooses, it can have a voluntary sign-in, so long as that sheet specifies it's permissible. And any member of the public is free to videotape, take photographs, or record the meeting itself, so long as they're doing it in a way that's not disruptive. And there are no secret ballots, meaning that every action that's taken by the council, commission, or board needs to be orally voted on. So that doesn't mean it has to be a roll call vote each time, but it means that there has to be a voice vote, either aye, yes, or no. So you can't deliberate on an item and then and approving something, do a secret ballot. Which would mean that it's unclear on who voted yes or no for a particular action.
Trevor, real quick, everybody, just as a reminder, please mute your phones, devices. But we're hearing a little echo in the background. Please mute your devices. Thank you.
So these are the exceptions to when things don't need to be on the agenda. The first one would be an emergency situation, and this would really truly need to be an emergency. So if something arose and requires immediate attention, it would require a majority vote of the council to put this on the agenda and then be deliberated on by council. The second exception deals with urgency items, and urgency means that the issue came to the attention of city staff or a council member, board member, or commissioner after the agenda had been posted, and it really needs to be urgent. So it can't be that if someone failed to properly keep track of a grant deadline and now there's an urgency that the council has to approve this grant before a certain date, and this is the only way that they're going to be able to meet that deadline, that wouldn't qualify. It really needs to be used in very limiting circumstances, and it really needs to be something that the board or the council or the commission otherwise didn't have notice of. So as I mentioned before, the public has a right to participate at every meeting, and that's what the Brown Act's core purpose is ensuring that the people are informed, are aware of, to the extent that they want to be aware of, and have the ability to participate in the actions of their government. And so what that means is the public also has a right to comment on agenda items. That means every agenda item that's posted. And what's important here is to make sure that there's no limitation on comments, even though they're negative. And I think it's important to remember that if they're using their allotted time, they're allowed to say what they want to say, so long as it's not inciting violence or threatening anyone in a specific way. So that's a pretty broad spectrum of what can be said by a member of the public during the public comment period. The city has established public comment guidelines as well as comments for each item. And it's just important to note that the ability to comment on agenda items specifically, this doesn't deal with the general public comment or citizen comment period, but the right to comment on items being considered for approval, discussion by the council. The public has a right to comment either before or during consideration of the item, so long as that period happens before the final consideration or vote on that item has occurred. Closed session, and this is the exception to the Brown Act's open meeting law, and it's focused on balancing this notion of the public has a right to understand and know about and participating in what their government is doing. At the same time, the government needs to have a certain amount of ability to keep things confidential, to have full and frank discussions that are not subject to public disclosure unless otherwise authorized by the council. And that's just identifying certain business needs that a city has. And so closed session can only be held for specific purposes. Those are defined in statute as to what those purposes are. When you're creating an agenda, there are specific safe harbor language that's contained in the government code. And the open session announcement of what occurred during the closed session is specifically authorized by the board, commission, or council. And so some of these say board members, but it also it applies to council members as well. Any attendee of a closed session, authorized attendees, so that would be a council member, in certain circumstances, the city manager, myself as the city attorney, authorized labor negotiators, or real property negotiators. Only those that are authorized to be in the closed session may attend that closed session, and everything discussed within that closed session remains confidential unless the majority of the council votes to make the content of those discussions or particular actions or certain information that's revealed during that closed session public. And that's by statute. There is a specific government code section that addresses specific confidentiality of matters discussed in closed session. And violations of that can lead to potentially criminal penalties. And so some of the examples of closed sessions would be discussion of pending litigation or threatened litigation, real estate negotiations, public employment negotiations. That would be, specify officers or officials that are directly under the purview of the council, as well as labor negotiations. And that would be specific to bargaining contracts, not negotiations specific with specific entities that report to the city manager. we've covered the bulk of what the Brown Act requires. These consequences, I think the most important one to highlight is the loss of public confidence, because sometimes a violation of the Brown Act may occur inadvertently. However, it's important that if a violation occurs, that we correct it. And that's important to identify for at least members of the public that this was an inadvertent violation. It's being acknowledged now that, if for this violation is being corrected, and that helps the public confidence and trust in their government. Some of the other violations include nullification of any decisions that have been made that were in violation of the Brown Act. An example of this would be if an item was up for discussion and direction, and the council ended up approving or finalizing a decision, that would be a violation of the Brown Act. Willful violations similar to Section 1090 can lead to criminal penalties. These are rare because most of the time, as I mentioned, Brown Act violations are inadvertent and not intentional. Sorry, a duplicate slide here. Now for our, before I go to the quiz, are there any questions on the Brown Act, meetings, agendas, closed session, and violations? All right. So now on to the quiz. And this video, I don't think is going to work, but it's these two gentlemen who are quite known in Southern California who go to different city council meetings and comically request the council to save or do something that is somewhat outrageous. And in this example, these two gentlemen want to save house parties in the Hollywood Hills, and the city of LA only gives a minute time. And so the question is, are their comments permissible? And I can answer it because the video isn't there, but the answer is yes, because the two individuals, although their comments, and unfortunately not able to see them, they are outrageous and are comical. They are crafty enough to understand that they have to talk about something that's within the subject matter jurisdiction of the body, which in this particular case is the Los Angeles City Council. And so because they're talking about something that's within the jurisdiction of the Los Angeles City Council, even though it's ridiculous, they're saying house parties should be saved and cake stands and drinking and partying is crucial to their development as youth. Those comments are permissible public comments because, again, they're speaking about potential regulations pertaining to noise and disturbances. Some other examples of this are, I've seen a video of a gentleman in Nebraska arguing for chicken nuggets just to be called chicken. And so it really, during public comment, as long as they're talking about something within the subject matter jurisdiction of the city, it's permissible public comment. So this is the next question. A director emails a newspaper article pertaining to an upcoming agenda item to the other directors. The director indicates that she supports the decision on the agenda based on the article. And 4 directors respond back to the email and indicate they also support the item. That the information was very helpful. Was this a Brown Act violation? And I think this is pretty obvious. Yes, the directors participated in discussion of an item within the subject matter jurisdiction of the body because there was at least a quorum. It was actually all of them that were responding, and it was not at a notice or open or public meeting. And so again, this just goes back to the example I said of the reply all with emails. Sometimes it's important to be mindful when your emails are so easy to send. You just want to be mindful of who you're responding to, if it's your fellow council members or board members or commissioners. You want to make sure that you're not responding to a quorum. and unless you're wishing someone a happy birthday or some other thing that's not specific to the subject matter jurisdiction of your role as a public official. The next section under the Government Transparency Law deals with the Public Records Act. And the Public Records Act attempts to balance the public's right to know with, so that would be transparency, with this idea of privacy. And so it's a constant balancing act. So I will say the Public Records Act stresses or puts the emphasis on disclosure. That means if there's an exemption or you're withholding something, those exemptions or the withholdings should be narrowly construed. And that's how the courts consistently apply the Public Records Act. If you're ever concerned, you should always err on the side of overproduction rather than withholding more. And so that's a difficult balance because sometimes dealing with could contain personal information, and we'll go through some of those exemptions and examples of when it's right to. What happened there? Is there a red circle on the screen? Okay. I think we're back. So this is the basic rule regarding Public Records Act. A record is defined broadly, so this is not just pieces of paper. So it's any tangible thing containing information relating to the conduct of the people's business prepared, owned, used, or retained by the state or local agency, regardless of the physical form or characteristics. This could be emails, this could be text messages, this could be voicemail messages saved on your phone. It could also be microfiche that's put away in storage. It's construed broadly. So tangible thing, it covers pretty much anything that could be within the city's possession or the public official's possession. The Public Records Act requires that the city assist its requesters. And so what this means is if a member of the public makes a request and it's unclear or it's vague or it's confusing, the city can't simply say, request denied. If it doesn't understand the request, it's required to seek further clarification from the requester. If the requester makes what seems to be a reasonably identified request, there's a requirement that the city provide assistance to the requester in identifying or making a more refined search for records. And here are some of the exemptions to disclosure, and we have draft, pending litigation, personnel records, health records, or other insurance records, closed sessions, attorney-client privilege. And as I mentioned, these exemptions are applied and construed narrowly. So they really require a thorough understanding of when to use them. So if anyone has a question on whether something is or isn't subject to the Public Records Act and whether it needs to be disclosed, your rule of thumb should always be that you're giving everything that you think is responsive to Monica or whoever else is requesting the information from you. And then the city will make the determination about what is and what is not exempt from disclosure. So after 2018, a Supreme Court case, which is known as City of San Jose versus Superior Court, the California Supreme Court has held that emails and text messages and other records stored on public officials' personal devices and personal accounts. So if you have a personal Gmail account or Yahoo or some other type of personal email account, those messages, even though they're in your private phone or might be on your private number, not paid for, if they pertain to the public business, they are subject to disclosure under the Public Records Act. And so if you have text messages that are with a member of the public that are communicating things that are going to potentially be coming before the council or issues that the council is considering addressing, even if that's on your personal phone and the city doesn't pay for that phone, those text messages under the City of San Jose case are subject to disclosure under the Public Records Act. So, the best rule of thumb here is if you do use your private email accounts to conduct business that is part of your role as a public official, whether that's a council member, commissioner, other elected official of the city, or a board member, you want to make sure that, one, if you're going to continue using your private email account or text messages, that you are forwarding it to some type of city email account. That if you don't have a city email account, that you're forwarding it to a folder that you can easily reference. And that way, if a request does come in for your emails or text messages, they're not very common, but sometimes they do occur. That way you have the ability to quickly access those records and provide them to the city. And the last point on this slide is that if for some reason there's an inadvertent release of what would otherwise be a privileged or exempt document, if it's an accidental release, we don't waive that privilege. So this is allowing the city to go back and claw back a record that might have been released. With time. Over the course of several years, two council members exchanged emails and text messages about properties in the city with delinquent payment issues. They exchanged no other text messages. All the emails and texts were sent to and from private email and phone accounts. Members of the public asked the city for all communications between the two council members. How should the city respond? And again, this is based on the City of San Jose case. Those communications, because even though they're on private emails or text message accounts, because they pertain to the public's business, and that is, just for reference here, the shut-off or payment issues, delinquent payment issues, that's within the city's purview, part of the public's business, and they would be subject to disclosure based upon the ruling in the City of San Jose versus Superior. So our next section, and this is the last section under the AB 1234 required statutory training section. We're going to deal with laws relating to fair processing. So I'll just pause. I think there's a question. So the question is it allowable to delete emails, texts, or otherwise pertain to the public business? The best practice would be to forward any emails or text messages. If you can take a screenshot of it, if it pertains to the public business, to a city email account, so it can be retained in accordance with the city's record retention policy. If you have a procedure of routinely purging or deleting your text messages in your phone, that's fine, but I think you want to be sure that if it's pertaining to the public business, you would want to potentially save those pursuant to the city's record retention policy. Okay, so the next section we're going to cover are common law bias prohibitions, due process requirements, incompatible offices, incompatible activities. And then we'll finish with competitive bidding requirements for public contracts. Then we'll dive into city manager, city council form of government, and hopefully we can wrap this up early, a little early. And so, Councilmember Moran, I know you asked a question regarding, and I forget the specific question. I recall my answer being pertaining to there would potentially be a common law bias, and I think, as I'm recalling, it was with if there was a decision involving a family member who was not a wife or domestic partner or a dependent child. The common law bias prohibition says a public officer must exercise the powers conferred on him or her with disinterested skill, and diligence, and primarily for the benefit of the public. And what this means is, or what it goes to, is saying that as a public official, shouldn't and cannot be tempted by your own personal or pecuniary interest. And this applies to both financial and non-financial interests. If you have a common law prohibition, disqualifies you from participating. This is probably one of the most difficult to address because it is very. So the common law bias, we would want to look at all the specific circumstances of the particular situation, analyze whether is there a financial interest, is there a conflict under the Political Reform Act and FPPC regulations. Would then move down to whether there's a Section 1090 contract, a Section 1090 issue, and whether it involves a contract. And then we would move on to common law, whether there's a common law conflict. And this is incumbent on each public official to make this determination for themselves. Obviously, if there are specific factors which would lead a reasonable person to conclude that there is or there's no way that a public official could act with disinterested zeal, that would be a different conversation. The only example I'm familiar with of where an outside entity, not the public official themselves, was able to claim that a public official had disinterested zeal dealt with the development of a large shopping center. And the public official had publicly stated in comments to the media, as well as in community meetings, that there was no way, or there would be no possibility and no way that this public official would ever vote in support of this particular shopping center or the development of this area, that shopping center. And they repeatedly said this throughout the media, and that was their position. And they took a rather hard line in saying it didn't matter what evidence was going to be presented, they were going to be saying no. The developer of that shopping center successfully brought a claim, challenge against that specific public official, stating that based on their prior comments and actions, statements, there was verifiable evidence that the public official had proven that they were unable to act with skill or zeal in regards to the consideration of the approval of this particular shopping center. So again, that is the only one in recent memory I'm aware of this occurring. And so that's just another word of caution to be mindful of in your statements to members of the public, as well as to the media and even your fellow commissioners, council members, or board members, is that you can take a position on a particular issue, but you want to make sure that you're not eliminating the possibility to be persuaded a different way based upon evidence that's presented to you, or public comment that's made, or presentation. So just be mindful of taking very absolute positions on particular topics. There's no prohibition against taking a position on a particular topic, but you want to make sure that you leave it open enough to where you're able to accept information that's provided to you, whether that's testimony, physical evidence, or public comment, and act with an unbiased opinion and deliberating on the particular action that's going to be considered. due process requirements are requirements that are established by the U.S. Constitution, and these requirements apply to quasi-judicial matters. And as an example, they would be dealing with like a fine or a permit process. And so what due process means is that if you're going to be impacting constitutional rights that every citizen of the city has, whether that's monetary fine, impacting their, like water shutoffs or ability to build or construct something on their property, they have due process rights. And what that means is they have a notice, an opportunity to be heard, and that's by a fair and impartial decision maker. And so I think, with some items that are considered by the Planning Commission decides to not approve a project or not grant a conditional use permit, there's always the opportunity for that decision to be appealed to the City Council. That is because of the due process requirements guaranteed to the citizens of the city by the U.S. Constitution and even the California Constitution. So the doctrine of incompatible offices is stating that a public official cannot hold two public offices simultaneously if there is a potential for significant overlap in the duties or functions or responsibilities of those two offices. The idea behind this doctrine is that you can't have two allegiances. So as a public official, if you are a council member, if you are also thinking of running as a school district or school district board member, and the city and school district have overlapping functions or responsibilities, which, in this case they would, you as a public official can't have two allegiances, one to the school district and one city in your roles as a city council member, as a school member. And so what the law says is that once you assume the second office, if the two offices have overlapping responsibilities or functions and there's a potential for conflict, the minute you accept the second office, public office, you automatically forfeit the office you previously held. So in the previous example I gave, the council member became a member of the school district board. The minute they are sworn in as a board member of the school district, pursuant to Government Code 1099, they automatically forfeit their office with the city. So this is this can be a tricky issue to work through. And so if you, as a public official, have been offered to be appointed to a different board or thinking of running for a different public office, please reach out to myself early. That way we can identify whether there is a potential of a doctrine of incompatible offices applying. In some cases, it could be perfectly fine, but these are very similar to conflict of interest analysis. Doctrine of incompatible offices is very specific. There's a limited body of opinions in general detailing specific situations in which these incompatible offices doctrines, the doctrine itself applies. So it's just important that if you are considering being appointed or running for a different public office, please let us know so we can make sure that the doctrine of incompatible offices does not apply. So this deals with anti-nepotism laws and policies. Really, these laws are focused on addressing self-dealing, so personal benefit to either your spouse, domestic partner, or your dependent children. As I mentioned previously, the Political Reform Act specifically addresses financial interests when they deal with one's spouse, domestic partner, or dependent children. As I mentioned previously, the common law bias may or will require recusal in many cases. and those are fact-specific analysis. The competitive bidding requirements, public works projects are governed by the Public Contract Code as well as the Labor Code. And it's important to note here that competitive bidding requirements are not to protect bidders. It's really to guard against favoritism, fraud, and corruption, and to ensure that there is a level playing field for all contractors to do business with the city. Another purpose or intent behind the Public Contract Code and competitive bidding is to prevent waste of public funds. This is generally, with public contracts, or at least public works projects, low bid, the lowest responsible and responsive bidder is the one who obtains or is recommended for approval of this particular contract. So are there any questions on the issues I just covered? For reference, there was common law bias, doctrine of incompatible offices, or any other issues dealing with nepotism or public contract code, public bidding. Okay, so the quiz. A council member's best friend is applying for a city grant program. There are limited city funds, and the city received dozens of applications. The council member knows that his best friend will be very upset if he does not vote for his application, and it could affect the relationship. Can the council member participate in the decision to award the grant? And this really falls under the common law doctrine of whether there's a common law conflict of interest. So the answer is it depends. And again, this is what makes common law conflicts of interest so difficult, because it's really incumbent on the individual council member, the individual public official who's participating in that discussion to analyze for themselves whether they can act with disinterested skill, zeal, and diligence for the primary benefit of the And in many circumstances, they can, and this would be perfectly fine for them to participate in. But again, as I mentioned, determining these common law conflicts of interest, a large portion of the time are going to be very subjective. So it's going to be a determination that each individual council member, unless there are blatantly obvious facts that would lead a reasonable person to believe that there's no way that a council member can act with disinterested skill, zeal, or diligence. For the most part, most circumstances, there could be the appearance of impropriety, or there could be some other type of recommendation that, I would make that, hey, I think this would be better for you to sit out, just because of all these different factors that may lead to some questions or some mistrust from members of the public. Given the fact of this case, going back, I would argue strongly that if the council member is very concerned about how their friend is going to, how the decision is going to impact their relationship with their friend, I think there's a strong argument here that if that is weighing heavily on you and your decision making, there's a strong argument that you're not acting with disinterested skill, zeal, and because you're having this deliberation about your personal relationship, when really the focus of your decision-making process should be on the actual decision itself, not your personal relationship with a particular person. Question 11, and this deals with the doctrine of incompatible offices. The council member of East Apple City is elected to the East Apple County Board of Supervisors. May the council member serve in both roles? And no, this is about as clear-cut of a example that we can give regarding the doctrine of incompatible offices. There is, between a county board of supervisor and a city council, a overwhelmingly large clash of overlapping duties between the two offices. And the penalty here, or I don't even know if it's a penalty, just the result is the minute that the public official is sworn in as a board of supervisor, the board of supervisor has deemed to be forfeited their position on the city council. So section 5, and this is where we break from the AV 1, 2, 3, 4 training, and it's particularly covering the city council, city manager form of government. So in California, the overwhelming majority of cities are general law cities. So there are two types of cities, general law cities and charter cities. General law cities are the majority of California cities' form of government. And in those general law cities, the city council zeal or disinterest, when does that determine? I'm assuming it's when does that determination occur? Certainly not after the action was taken. Can you elaborate on it depends? So my use of it depends is regarding, oh, sorry, I guess that's a question specific to the quiz. The it depends part. So this determination needs to occur before the decision happens. And so, which is why if there's an agenda posted and that's sent to the commission, council, or board, it's important to go through that agenda and look and see if there are any items where, one, you may have a financial interest in or a potential financial conflict under the Political Reform Act, or if it involves any business that you may have a financial interest in for 1090, and then going through and looking at, okay, I've done those. Do I know anyone that's involved in these particular projects? Is it a family member? Is it a very close friend? And then making the determination for yourself, you act with disinterested zeal. Disinterested zeal really boils down to mean you are putting the public first, meaning not your own personal interests. And so the it depends part mean in this situation for this quiz is dealing with if that council member, before the decision is made, makes the determination that, yes, I can act in the public's best interest. I'm not worried about my personal relationship or how my decision on this particular issue is going to impact my personal relationship with the individual who's seeking the approval of this grant, which is from the example, then that's sufficient. I mean, if you've made that determination, you can act in that particular way. There's no common law conflict of interest. However, if you are having serious doubts and where you're more concerned about your relationship with this individual and how your decision on this particular issue is going to be impacting your relationship, rather than how your decision, rather than weighing the merits of the decision and whether this is in the best interest of the city, if you're more concerned about your personal relationship, then that is when you, as a councilor, would have a common law conflict of interest. I hope that answers the question. So going back to city council, city manager form of government, this form of government is the overwhelming majority of government in California, and I would probably assume for most of the United States. It is this model where the mayor and council, in some cities, it's just city council members and the mayor is appointed. But for this city, it's mayor and council directly elected by the citizens, and then city manager is appointed by the mayor and the council. And it's the ideal behind the city manager, city council form of government is that if you take a company, for instance, or a corporation as an example, a corporation has a board of directors that oversees the general big picture management of the organization. And give guidance, sets policy, sets the direction and approves of major decisions that are going to be impacting the company. That example is analogous to what the city council and the mayor's roles are as far as the city's government. The city council sets big goals, overarching policies, strategic plans, and then similar to a corporation, going back to the example, corporation has a chief executive officer or a president that's responsible for the day-to-day operation, handling personnel issues, dealing with the nuts and bolts of getting things done. And that is how the city manager form of government works. City manager is charged with, effectuating those sort of day-to-day operations and issues on behalf of the city, and then reports directly to the city council itself. So using that example, city council's roles and duties, the city council is the legislative body of the city. It makes decisions, it legislates. It can enact new regulations that are imposed through ordinances, can set rates for different types of fees and services. Those are things that are legislative in nature, and that is what one of the city council's responsibilities and duties are. And the city council is also responsible for the broad policy making and direction of the city that deals with, the general plan, strategic planning, any other guidance it wants to give, direction it wants to give based upon, the majority will of the council. Additionally, the city council approves budgets, fees, contracts that are above city manager's authority, financial policies, employment bargaining agreements with the different unions. But it's important to point out here, they do not approve of any other employment agreement that does not directly report to them. So, the two individuals that would be employed by the city council would be myself, the city attorney, and the city manager. And again, I think this is the key point here is that as city council members, you are directly elected by the citizens. And as directly elected representatives, you have the duty to respond to their concerns, hear their concerns, and try, and, in a certain sense, you're elected to try and convey what you believe is the best course of action for the city. And in that sort of big picture, the city council then uses or, directs and empowers the city manager to effectuate bringing about those changes or implementing those policies. Again, the city manager's roles and duties are really managing day-to-day operations of the city and having a wide array of different expertises and management and dealing with things that arise on a day-to-day basis. The council only meets twice a month. There's a lot that happens in between those meetings, a lot of things that require constant attention, and that really falls on the city manager. And that's why there's this form of government to deal with a separation of powers, because as any CEO or president of an organization, they need to have the ability to employ their own management style, their management tactics to give the results that the city council or a business, the board of directors expects. And so to that end, the city manager is also responsible for recruiting, hiring, or terminating, as well as supervision of all city staff. And that's important. As I mentioned, there are only 2 individuals that are appointed directly by the city council. So it's important to recognize that line of any issues coming from or arising from city staff need to go through the city manager. Some of the other roles and responsibilities, and again, these are general roles and responsibilities. There are specific enumerated roles and responsibilities that are defined in the municipal code, but I think these are a good summation of everything that's within the city manager's role and purview. And I just wanted to reiterate this point where the city manager is the chief personnel officer of the city. That everything regarding city staff, whether it's complaints from members of the public, the police department, obviously there's formal police officer complaint process, but generally any concerns regarding city staff need to go through the city manager or someone else the city manager designates. Then that's because the city manager is the chief personnel officer of the city. And the municipal code, and this requirement is no different than any other general law city that employs the city council, city manager form of government, is clearly stating that any personnel issues regarding city staff, concerns need to be either reported to or dealt through the city manager unless otherwise authorized by the city manager. And these are some of the benefits of having a city council, city manager form of government. It's really having the ability to have a central executive that has a broad range of expertise and abilities to deal with problems or issues or crises that may arise and do arise. As I'm sure the city manager can attest to, there are hundreds of issues that arise in a week that require immediate attention. And this is kind of the benefit of having this central executive that's able to act on behalf of the city to ensure the city continues to operate at a high functioning rate. It also allows, in the recruitment and hiring of a city manager, you're hiring someone that has a deep expertise over a myriad of different issues. There's obviously personnel issues, there's general plan issues, there's planning issues, there are construction issues. And so having this key individual be the leader of your organization, of the city's organization, is important because it allows for the council to focus on the big picture items. And so, the council can set priorities and provide direction on its expectations, and then allows those things to be efficiently funneled through the city manager for execution. And that's what occurs in the city. And having this type of structure is not only efficient, but allows for a more collaborative environment to where you're having a single focal point of contact. Not to say that individual council members can't reach out to key staff members for information, but having the city manager at the top of your organization is crucial. And I think, that's exemplified by I think it's about 450 or 460 other cities within the state having this specific or exact form of government. It's proven to be one of the most effective forms of government, especially for cities that are not enormous in size. And so it allows for having this responsiveness of council being able to both be involved in the day-to-day, big picture things that are occurring, while allowing the city to operate efficiently under the purview, direction, and management of the city manager. So are there any questions on the city council, city manager form of government? Any questions regarding anything we just covered? So I tried to, and I think we're going to finish about 15 minutes early. So that's all I have, and I appreciate everyone's time.
Thank you, Trevor, for an excellent workshop and training session. Does anybody have any further questions or comments? Anybody presently here, council? Any questions? Jose? City manager? How about on the phone? Anybody on Zoom? Anybody have any comments or questions?
Yeah, Mayor, this is Councilmember Kang. Got a question real quick.
Yeah, go ahead.
Hey, are we going to get some kind of written documentation about this meeting that we attended?
We usually do have a, Trevor, if you want to jump in, but we do usually get a certificate certified, and we attended this training, and it's good for 2 years.
And then can I also use the same training for my mosquito abatement, or I have to attend their separate meetings?
So if the mosquito abatement requires AB 1234 training, Councilmember Kang, this would be sufficient. And I think I'll work with the city manager, but I think our office, I think in the past, has prepared the certificates, and we will do that again for this training as well and make sure that everyone who's attended, and I will get the list from Monica, we'll make sure that everyone receives their certificate. And then Councilmember Kang, if anyone from the Mosquito Abatement Districts Council wants to reach out to me or has an issue regarding the sufficiency of this training, I'm happy to have that discussion with them. But I do believe this would meet their requirements.
Perfect. Thank you, Trevor.
Thank you, Trevor. Any further questions? Anybody on Zoom? It doesn't sound like any. Once again, I want to thank everybody for attending our workshop for these past 2 days. We thank Trevor for putting this workshop together and training, and hopefully everybody benefited from the information presented. At this moment, we're going to go ahead and adjourn our meeting at 7:14 p.m. Everybody have a good evening.